Thank you for staying with us, everyone. The Supreme Court has affirmed the constitutional powers of the President to declare a state of emergency in any state of the Federation to avert the breakdown of law and order. A 7-member panel of the Apex Court, in a split decision of 6-1, equally declined to fault the suspension of elected officials in states under emergency rule. However, it stressed that such suspension, though necessary to ensure that the prevailing situation in the states did not degenerate into chaos or anarchy, it must be confined to a limited period. The judgment followed the dismissal of a suit that 11 states of the Federation filed to challenge what they termed as President Bola Tinubu's unconstitutional actions in Rivers State. Is political negotiation now more active or more effective than litigation? What constitutional safeguards should states rely on? Did the Supreme Court miss an opportunity to clarify important constitutional issues, or was this decision legally inevitable? Constitutional lawyer Malachy Ugwummadu joins me for answers to these questions. Mr. Malachy, Merry Christmas in advance and welcome to the program. Thank you for joining us this evening.
Compliments of the season. Appreciate the opportunity. Good evening, viewers.
Good evening to you. So, Supreme Court has given a verdict affirming the constitutional powers of the President to declare a state of emergency in any state of the Federation to avert the breakdown of law and order. How do you interpret this?
Well, I think this is perhaps one of the most crucial decisions that has come out of the Supreme Court of Nigeria this year, our Lord's year 2025, in the sense that it is a judgment that touches on the true concept of federalism in a nation. That judgment, first and foremost, came a bit lately, at a time when all the undercurrent waters had literally evaporated before the judgment was eventually handed down. What I mean by that is that the principal participants, like the governor of Fubara of Rivers State, had moved from the political party he was to yet a new political party, which is the ruling party. All the members of the State House of Assembly, the institution that was struck down, so to speak, had also moved.
Not all of them moved. Barrister Ugwummadu, not all of them moved. Some are still with the PDP as we speak.
Maybe you didn't hear. I said virtually,
okay.
all
of them.
Yeah. But the majority of them moved. That. So, well, straight to your point, it is a judgment that for us lawyers emphasized what the law is, but needed to leverage on that life case to properly delineate the powers of the president. Section 305 of the Constitution, no doubt, grants Mr. President the power to declare a state of emergency, which must be gazetted, and that proclamation must come to the President of the Senate and the Speaker of the House of Assembly. The whole idea is to garner the appropriate two-third majority to rectify what has done. That power is not in dispute. What is in dispute is whether the President, in exercise of that power, particularly talking about extraordinary measures, can he strike down, can he dismantle democratically elected institutions in any particular part of the country that is affected by that state of emergency. That didn't quite come clearly. Whereas you could say that the Supreme Court judgment affirmed the powers of the President to declare a state of emergency, the Supreme Court judgment did not go as far as saying that it was unconstitutional, illegal for the President to have, in the exercise of that power, in the process of that proclamation, dismantled democratically elected governments in any part of the country. That is what has left the gap that is being condemned momentarily. So for me, it is good that eventually the judgment came out. It is no longer in dispute that the president has powers to declare a state of emergency, which is black and white in the Constitution, referencing Section 305 of the 1999 Constitution. What left to be done, leveraging on that life case and relying on what we call case law, was to properly situate the matter and the judgment in a way that no longer leaves any ambivalence as to whether or not, in exercising that power, whether a president has the virus to dismantle, elect, democratically elected government. Because the reason why that is important and very crucial is that if you look at Section 1, Subsection 2 of the same Constitution, it talks about the sanctity of government in Nigeria, and that no person, no authority, no president has the right to take over the governance of the Federal Republic of Nigeria or any part thereof, except in accordance with the Constitution of the country. So the issue is where the president is given a discretion to deploy whatever measures in an extraordinary manner. Does that authorize him to act illegally? That for me was the big question that was not answered in the judgment. And I think that as we continue to review this particular judgment, the answers will soon be found, leading up to what we may now turn into campaign issues, considering that this is already a Supreme Court judgment.
Absolutely. And given your interpretation of this verdict, Mr. Ugwummadu, because Section 305, just as you said, does not clearly define the extraordinary measures available to the president. And you've also indicated that there is a constitutional gap. Two questions tonight. Is the president's discretion absolute or subject to constitutional boundaries? Are there actions that would clearly fall outside the scope of Section 305? Even during an emergency, can discretionary power under Section 305 override fundamental rights? And also, does a lack of specificity in Section 305 increase the risk of executive overreach?
My take is that that power is not at large. Okay. In fact, if it were at large, we won't find other corresponding constitutional provisions trying to limit the powers of the president even during emergency. So what we needed to do is to find a way, using this life case, to define or characterize what extraordinary measures would mean and would not mean. In my view, and this is my humble position, the idea of dismantling, the idea of removing a democratically elected governor, suspending a democratically constituted state of assembly, whether momentarily or temporarily, for me was an overreach. The other issues that also problematized this situation was a question of how the president came to the conclusion that there was imminent danger, that Nigeria was at a state of war, and that part of the country has found itself in a situation that introduces serious violence and chaotic situation that required the extraordinary measures. But those are gone now. The issue now is if we should move forward from here, I think that the states led by the Attorney General of Adamawa and 10 other states, I suppose, needed some clarity, as it were, to be sure that if this was the way the president saw the police power as he interpreted them, was it possible in a democratic setting that where such situation repeats itself in yet another state, the president would act the same way? I think that was what led them to court in the first place. And having not gotten what they wanted, will now return to the legislature as an institution of government seeking for the amendment of that particular section of the Constitution that introduces enough clarity, that removes all manner of ambiguity, that leaves no one in any state of ambivalence as to what extraordinary measures means, as to whether or not the president has the constitutional power or right to dismantle, in my words, a democratically elected institutions like the office of the governor, like the State House of Assembly. I think when we are done with that, we may have then finally buried this matter. But as it is, there are still gaps, and our mouths are still wide open, seeking for answers.
All right, and because you just touched on the Supreme Court verdict on the 11 states of the Federation, the filed to challenge what they term the president's unconstitutional actions in Rivers State, I'm curious to know, what does this decision reveal about the Supreme Court's current approach to politically sensitive cases? What lessons should state government learn from this outcome?
Well, I'm not sure I quite understood that question, but if you are talking about how our cases travel with respect to how fast our cases travel with respect to politically exposed matters, I think the answer is out there for every person to see. You have instances in which it is very difficult to have cases dispensed with within reasonable time. While in politically exposed cases such as this, they are dispensed with within a year. Now, I can tell you as a practicing lawyer that we have cases that take more than 10 years, a decade, to conclude, even at trial level. And you can imagine what that would mean if it gets to the intermediate court and then to the Supreme Court. I can see, as a practitioner, the preference that is accorded politically exposed matters in contradiction with other categories of cases that desire and deserve the same justice that we all seek in the Temple of Justice.
All right. Mr. Ugwummadu, what lessons should state governments learn from this outcome? And as you know, currently the Speaker of the Rivers State House of Assembly has accused the governor of deliberately sidelining lawmakers and setting the stage for another crisis in the state. How should states approach future constitutional disputes?
That's a tricky one, but it goes to the character of the state. And what I mean by that is that from this judgment, it is obvious that we have a skewed, if you like, a flawed federal system of government, in which the juxtaposition of state powers that ought to be at par in relation to the tiers of government tilts in favor of the federal government, and in particular to the president. If the same constitution that grants Mr. President the power, this sweeping power, and now affirmed by the Supreme Court to declare a state of emergency, and by extension, dismantle the democratically elected government in that tier of government, if the same constitution allows that, and now affirmed by the Supreme Court, it becomes a very strong signal to the subnational states to watch their acts. In fact, it is even more important to realize that the state don't even need to be at war or imminent danger of violence or war. It is more of the discretion of the president, the political exigency that the president reads, and the political calculation that the president can ascribe to each situation. In fact, this judgment tends to suggest that a president of the Federal Republic of Nigeria can send political actors in any part of the country to political purgatory at any time.
And one of the questions I asked before I brought you on board was, is political negotiation now more effective than litigation? And also, while you advise state governments, what constitutional safeguards should states rely on?
Well, the lesson for state governors and state governments is to realize that there is no merit in overheating the system. You know, Rivers State, in fairness to them, didn't come close to the nature of violence that we have witnessed in most parts of the country within the same time. Rivers State didn't come close to that. But what Rivers State threw over the board was the piece of poverty, the piece they needed to guarantee the minimum security that they needed to have. What I mean by that is that the system was overheated, and the political actors in Rivers State, no less one of the appointees of Mr. President himself, escalated the situation and aggravated the circumstances in such a way that the president felt justified, at least to ensure that it doesn't go beyond what they had at that moment. And don't forget, my sister, that Rivers State captures the essence of the political economy of our country. In other words, whatever affects Rivers State, like Delta State or Cross River State, as the case may be, Bayelsa in particular, touches on the political economy of this country. In other words, what does Nigeria stand to lose if Rivers State degenerates into a crisis situation? From that moment, we could see that it's not merely about being in a state of war or imminently anticipating war. Once the economy of the country is threatened by reason of the political activities going on, that was sufficient. Therefore, realizing that the president now has this kind of power, other states should watch and understand carefully the character of our country, the character of the state, and the powers of the president in relation to the position that they occupy within the federating unit.
All right, constitutional lawyer Malachy Ugwummadu, I must appreciate you for joining us tonight and helping us with the positive and negative legal implication of the Supreme Court verdict. Thank you so much for your time. Please have a great evening. Thank you.
Thanks.
And let's go on another break, and when we return, we'll shift our focus to politics in Osun State. Please stay with us.